Tao Falilelo Jr. and Lex Logistics. Case number 2020-00460.
Good afternoon, Your Honor. John Butler, P33908 on behalf of the plaintiff.
This is Alexandru Leahu for Lex Logistics.
Okay, all right. So today's date and time set for a hearing. The plaintiff is wishing to, or requesting of the court to grant a default judgment against Lex Logistics. Is that correct, Mr. Butler?
It is, Your Honor.
All right. Do you understand what's going on today, Mr. Leahu?
This is one of those cases that makes every small business owner cringe. Because what you're about to watch isn't about fraud or theft or some elaborate scheme. It's about a simple mistake. A piece of mail that didn't get enough attention. And that one decision snowballs into a potential $25,000 judgment that could legitimately wipe out a business that's been operating for decades. This case is a textbook example of how the legal system doesn't care whether you meant to ignore something. Court orders don't require intent, only compliance.
He doesn't work no more. I don't know where he's at and all that. And I'm not really familiar with all this kind of laws, but I don't have to be garnished for nobody. I don't see how did I receive all kind of whatever stupid stuff what the person who used to work for me, I don't know, apply and all that. To be honest, I'm not familiar at all.
So, Mr. Leahu, the way this works is if you have an employee, okay, who has a court case against them and they owe money, the person who is owed the money, they can get a part of their wages, and you would have to participate in that. And that's why Mr. Butler and his client is looking for that information to see if...
This right here is where the wheels start coming off. Wage garnishment isn't optional, and it's not personal. It's a court-enforced collection tool. When a business receives a garnishment order, the business becomes a legally required middleman. The employer doesn't get to decide whether they agree with it, whether it's fair, or whether they feel responsible. Their job is simple. Respond to the order, disclose employment information, and withhold the required amount if applicable. And here's the key mistake. Ignoring the garnishment doesn't make it go away. That's how you go from "this has nothing to do with me" to "why do I owe $25,000? And unfortunately for this defendant, that realization comes way too late.
Monies that Tao Falelo, monies that this person earned, that Mr. Butler's client has a right to a portion of it, that they're able to successfully get those monies. And so you're saying right now this person does not work for you?
No, it doesn't work for months and months. No.
When did he work for your company?
Last year.
Your Honor, I see that the wage garnishment was filed, looks like October 4th, 21. We sent a failure to disclose letter in November, no response. We entered a default against the garnishee defendant last November, no response.
This is where documentation becomes a silent killer. Look at the timeline. The garnishment order is filed. A failure to disclose letter is sent. A default is entered, and still nothing. Courts run on paper trails, not explanations. Every missed response becomes a check mark against you. And by the time the case reaches this stage, the court isn't asking why you didn't respond. They're asking what consequences now apply. From a judge's perspective, this isn't confusion, it's non-compliance. Multiple chances were given, deadlines passed, and now the plaintiff is forced to ask for a default judgment. At this point, the legal system sees extra work caused entirely by silence.
It seems like if he would have simply answered the garnishment when it was originally filed, we wouldn't be here today. And if he's not a lawyer, perhaps he should talk with one. But we've had to do a lot of extra steps that would have been helped by filing the garnishment when he was required to.
Well, when the request ultimately is for a $25,000 judgment against Lex Logistics, I think it would be probably appropriate for the court, especially if it sounds like Mr. Falelo didn't work there all that long, that Mr. Leahy have the chance to at least talk to a lawyer about this. Mr. Leahy, you have an obligation when it's not, court stuff is definitely not stupid stuff, because it could absolutely have a huge impact on you financially.
And here it is. The sentence no business owner ever wants to say out loud in court. I don't pay attention to certified correspondence. Certified mail exists for one reason: to prove you were notified. Saying you ignored it isn't a defense. It's basically an admission. Courts assume certified mail equals importance. Ignoring it signals recklessness, not innocence. From a legal standpoint, this instantly reframes the case. This isn't about misunderstanding anymore. It's about choosing not to look. And once you admit that on the record, you've handed the court a justification to impose consequences. Judges hear excuses all day. But when someone admits they routinely ignore legal notices, patience evaporates.
That being said, if you don't have to deal with this very often, it would be something that is new.
In 20 years, I had some companies in 20 years, first time when I ever saw something like this. To be honest, I saw that it's not on my name. I said, Lex, I never pay attention. Now, when I got it, the last one, I really look a little bit into it, and I start pretty much look into the meaning of garnish and all that. And then I start calling your court and all that. And I say, hey, what the heck this one has to do with me? And then they start explaining me that I have to show to the court. I have to explain to you that he doesn't work for me and all that. But for me, maybe if somebody called me, explain me more about it. But I didn't even pay attention to the sum, to nothing. Once I didn't see my name, I get 100 stuff in my mail for a company. To be honest, if it's nothing, I know I didn't do nothing wrong.
This is the moment the stakes become painfully clear. $25,000. For many small businesses, that's payroll, rent, insurance, or survival. And notice how the judge frames it. Not as punishment, but as a logical outcome of an action. The court isn't saying, you're a bad person. It's saying, these are the consequences built into the system. What's especially brutal here is that this entire situation could have been resolved early with a single response. A letter, a form, maybe even a phone call. Instead, the defendant is now standing in front of a judge trying to explain why an hour of time wasn't worth preventing a 5-figure judgment. That math just doesn't add up in any court.
These answers, like I didn't know, or, those aren't valid legal answers for your failure to answer this garnishment back last year. So I'm willing to discuss these things, but you need to talk to a lawyer about this, because right now, Mr. Butler is looking to get a $25,000 judgment against your company. $25,000 judgment against your company. I would think at that point in time, it might make sense to talk to a lawyer. I can't tell you what to do. I can't give you advice. In my position, if I give you advice, then it looks like I'm showing you favoritism over the other side. I can't do that. And so, Mr. Leahy, I'm sorry that you haven't had to deal with this in 20 years. Thank goodness you haven't. But you're having to deal with it now. So I'm going to adjourn this 30 days. You might not have to hire an attorney, but you can at least talk to an attorney. So use that time. I will tell you.
Okay, but what do I have to do if the only thing, what I can tell you, he doesn't work for me and all that? Even if I talk to a lawyer, what can I do in this case? Because I don't have nothing to do to this person, and I don't have no idea.
This is where people get confused and where courts draw a hard line. You are not responsible for your employees' personal debts, but you are responsible for complying with court orders directed at your business. Those two ideas are not the same thing, and mixing them up is costly. The defendant keeps arguing fairness. Why should he deal with someone else's debt? The court's answer is simple: because the law says so. When the garnishment notice arrived, the business was legally required to act. The failure wasn't moral, it was procedural. And procedural failures are the easiest ones for courts to enforce because they're black and white.
Did work for you, and there was a time where they notified you, the other side, that's basically said, hey, if you're paying this guy some money, a portion of it has to come to us. and you didn't answer that. And that's a problem. And so that's right now, he's not working for you. That's fine. Then you don't owe them like any monies going forward. But there was a period of time where he was working for you. You need to talk to a lawyer about what your obligations are at this point when it comes to Zeal Credit Union.
Okay, and what we can do right now, because I cannot go back and forth. Even right now, I had to stop work for 1 hour just for, I don't have no work.
Sir, if you find, if you call the local bar association, if you look
okay,
for
but
a
what
business,
do I have to do in this case? Okay, what do you want from me now? Okay, this guy doesn't work for me. What do you want from me?
Mr. Liu, you need to stop interrupting the court. That's what needs to happen first and foremost. Stop interrupting me. All right? So I don't have to, frankly, right now you have no good answer for this. And the court could simply grant his motion for default, and then your company would have a $25,000 judgment against it. Why? Because you weren't willing to take a couple minutes, an hour. You say it's taken an hour versus 25,000. I can't understand that conceptually, sir, why you wouldn't.
This is only in this country can happen for me to own to somebody else some money, and I have to deal with this. You're telling me that it's my fault that I didn't pay attention to.
This emotional spiral is exactly what judges try to prevent. Frustration turns into interruptions. Interruptions turn into warnings, and warnings turn into consequences. Courts care deeply about respect for the process. The moment a defendant argues feelings instead of facts, they lose credibility. What's tragic here is that the judge is actually offering mercy. 30 days to consult a lawyer. That's not guaranteed. That's discretion. And instead of recognizing that lifeline, the defendant continues arguing hypotheticals and blame. Every second spent arguing is another second not spent fixing the problem. Judges notice that. Always.
Sir,
how should I, if I never pay attention to the money and all that, I didn't do nothing.
Sir, if you're a business person, then you are held to the same standard as any other business person running a business in this state, in this country. And that is, if you get a request of this nature, you're to respond to it. And you didn't. And so I'm giving you a chance here to talk to a lawyer and see what your options are. Now, you say you don't know anything about this. There are so many lawyers who do. And you say, I don't even know what to do or what to say. If you hand these documents to a lawyer, they will know what to do. So I'm adjourning it 30 days. If you want to come back here and say, I don't know what's going on, I don't really understand, and I've given you 30 days to go find out, then I'm not going to have a lot of patience for you, Mr. Leahy. But I'm giving you 30 days to have a conversation that probably will take less than an hour.
Tell him to send me again the paperwork, because I don't have the paperwork no more. I just made a screenshot for this court date. Tell him to send me another copy of those. I'll look into it with the lawyer, and that's it.
I would say talk to the lawyer about that. He or she can call Mr. Butler for any documentations that are any paperwork that's outstanding. I'm sure you have Mr. Butler's phone number. If you contact, if you give your lawyer, Mr.
No, I
Butler's
I don't have nothing. I just made the screenshot for my meeting ID, and that's it. I don't have nothing, to be honest.
We said, how did you know about today?
Because I made a picture from that letter to the meeting ID, and that's it.
The meeting ID has the notice has Mr. Butler's the other attorney's name and number on it.
But I called him at that time when I called your court to look into this, and I throw the paper away. I don't have it no more.
So here's the bottom line. This case isn't about intent. It's about responsibility. The judge hasn't ruled yet, but the warning couldn't be clearer. Ignoring court orders, especially wage garnishments, transfers liability directly onto the business. Whether the employee still works, there doesn't erase past obligations. And once defaults stack up, courts have very little room or patience for excuses. The lesson here is painfully simple. If you run a business, certified mail matters, court paperwork matters, and silence is never neutral. 30 days is this defendant's last real chance to limit the damage.